Welcome to Legal Yes, where we break down the biggest celebrity legal cases of the week. And I am joined this week with American's divorce lawyer, James Sexton. James, it is so good to see you again. Thanks so much for taking the time.
I'm happy to do it. Thanks for inviting me.
Before we get into the big stories of the week, let's talk trusted prenup. So what is this? How does it work? And how are we providing this to the stars come Oscar time?
Well, trusted prenup has been around for about a year now, and we're basically a way to democratize prenuptial agreements for people across all 50 states. We're using AI-backed technology to basically give people the ability to write the rules for their relationship. And yeah, we're very thrilled to be included in the gift bag of Hollywood's biggest nights. So whether they're looking for one or not, we're making sure that Michael B. Jordan, Leonardo DiCaprio, a lot of the people that have so far been smart enough to maybe duck the bullet of marriage are going to have that opportunity given to them, and I hope they'll avail themselves of it.
Definitely. Let's get into some of these big cases. This is a story that obviously has a lot of people talking. The Los Angeles County District Attorney Nathan Hochman says that the case against Nick Reiner could qualify for the death penalty, but stressed that decision is still under review. He has pleaded not guilty to the murders of his parents, Rob Reiner and Michelle Reiner, and waived his right to a speedy trial with his next court date set for April. Prosecutors say the case is moving forward as they await the final coroner's report. So given what Nathan Hochman said, how realistic is it that prosecutors will actually pursue the death penalty in this case?
Although they might be seeking the death penalty, it doesn't necessarily look like this is a situation where even if they were able to obtain a verdict of that kind, that there would ever be an actual execution. The fact that there was a waiver of the right to a speedy trial is really noteworthy, and that was something that everyone in the legal community was a little surprised by. The right to a speedy trial is typically something that the defense weaponizes against the prosecution. Remember, the prosecution has the burden of proof. An individual accused of a crime doesn't have to prove their innocence. The state has to prove their guilt. So technically, a defendant doesn't have to call any witnesses, offer any testimony. They can just have their counsel punch holes in the case of the prosecution, which is typically why you don't want to waive your right to a speedy trial. You want to put the prosecution on their proof. They have to do the heavy lifting. They have the burden of proof, and you make them do it as quickly as possible. So the defense strategy of waiving that right to a speedy trial in some ways gives the prosecution an advantage to put together the best case they possibly can without the constraints of time that come from a speedy trial. Now, what does this mean? Most tacticians and lawyers who are trial lawyers like myself, we look at this and we go, okay, they want some time to talk about plea deals. That's what the defense is thinking here. If we're forced to a trial, we're going to start seeing those plea agreements out the window. This is a public case. Everyone is watching what's happening here. So this may be an opportunity to move forward with a plea deal and encourage the prosecution not to take such an aggressive stance because they're concerned about time.
All right. So as we know, Prince Andrew was arrested by the Thames Valley Police late last week. He was released, and now everybody's wondering what is going to happen to him going forward, because he may have released official documents and things like that to Jeffrey Epstein. Where do you think Prince Andrew goes to from here? Obviously, he's going to be banished from the royal fold forever, but a lot of people are saying he could spend the rest of his life in jail.
I mean, look, the UK legal system and the US legal system are quite different in terms of burden of proof and even procedure, but I don't think anybody today wishes they were Prince Andrew. This is a very difficult situation, and I'm certainly glad I'm not his attorney, because that is a very, very challenging case that's presented against him. This is a situation where England and the UK are essentially taking the Epstein charges, one might argue, a little more seriously than the United States law enforcement is taking it, and they're making much swifter action. Now, the question is are they shooting first before they figure out what the targets are? Or are U.S. law enforcement being very careful about making sure that they have the strongest case possible before they start firing at targets? That tends to be what the United States law enforcement, particularly federal law enforcement, really try to do. They like to measure twice and cut once. They like to make sure that they have a conservative, strong case before they go in and start offering indictments. But again, this is bad news for the prince. He's certainly in a position where he's been out of the graces of the royal family for a long time for a myriad of reasons, but this is certainly the most damning pool of evidence that's ever been provided against him. And it's certainly something that any attorney looks at and says, I would not want to try to make a meal out of those ingredients, because it is not a favorable one for him, and it's a good one for the prosecution.